Hello everyone, welcome to KCC channel. Today we are going to discuss about an important amendment made by the budget 2021 regarding contribution of the employer towards various funds for the benefit of the employees. Basically, any contribution with regard to the welfare fund of the employees has two components, employee contribution and the employer contribution. An explanation has been added by the budget 2021 which states that any contribution made by the employer towards the welfare fund like PF, ESI, any other welfare fund, superannuation fund, the employee contribution has to be deposited before the due date prescribed under the relevant act. If that is not done, then that portion of the employee's contribution is disallowed and added back to the income of the employer. If we see the background of this amendment, this provision in the income tax law is there since very long. But there have been litigations and the assessees and the income tax have been at the loggerheads at so many occasions, and the courts have also given judgments at times in favor of the assessee, stating that even if the contribution of the employee is made after the due date prescribed under the act, even then it is allowed as a deduction and not added back to the income of the employer. Therefore, the government thought that an explanation should be added to it to make it absolutely crystal clear so that there are no disputes, there are no litigations, and therefore this amendment has been brought in. To understand it in a brief manner, supposing the salary of the employee for the month of February is due at the end of the month, and the contribution for the month of February has to be deposited. In the case of PF, it is 15th of the following month. That is, by 15th of March, the contribution has to be deposited with the PF authorities. If the contribution is not deposited by 15th of March, the employee contribution gets disallowed altogether. And the important point to note here is that it is disallowed forever. You can never claim it as a deduction, because there are other sections in which you can claim the deduction later on whenever you deposit it, but here it is never allowed. The employer contribution can be claimed as a deduction provided it is deposited before the filing of income tax return, due date of income tax return. So this is a very stringent provision. The employers must note it and make a note that the employee contribution should be deposited well before the due date prescribed under the relevant act. I hope you like the video and you find it informative and very important. Thank you for patient listening. Goodbye for now.